I think all are able to see you, sir. Natwarji,
Okay.
Satishji.
Yes, quite clear, quite clearly, sir.
Yes, sir. Yes, sir. We are seeing her.
We are able to see you. You are on the screen also now.
चलिए ठीक है चालू कर लीजिए आप तो.
You are wearing very good red jacket, sir. Very nice red jacket you are wearing today.
Thank you.
Young and vibrant colors. Yes, Megha. Let's begin. We welcome Justice Manish Mandari sir in our webinar. Megha, over to you. Please carry on.
Okay. So first of all, we apologize everyone for the delay in our webinar, though we never expected this the communication gap. So by starting, a very good evening to one and all present here. I feel extremely proud and honored to welcome you all in the 7th lecture of Dr. N.M.Ranka Memorial Lecture Series, organized in association with Lex Logical Club, which is being run by Manipal University School of Law and Rajasthan Tax Consultants Association and Consultant Association. So it feels immense pleasure to have opportunity to hear wise words from our chief guest. And the topic for today is, just a second. Yes, again. So we have our chief guest, Honorable Mr. Justice M.N. Bhandari sir, who will be telling us and guiding us about the topic examination of witness, which will also cover practical aspects along with the cross-examination, re-examination and examination in chief, which will be also co-chaired by our Honorable Mr. Justice J.K. Ranka. So now, with the beginning of our webinar, I would like to invite Advocate Siddharth Ranka to give welcome address on behalf of N.M.Ranka, Ranka Public Charitable Trust. Over to you, Siddharth sir.
Thank you, Megha. Honorable Justice Manish Bhandari sir, on behalf of Ranka Public Charitable Trust and the co-host Rajasthan Tax Consultant Association and Tax Consultants Association Jaipur, we welcome you, sir, with very, very warm heart. In this COVID times, we had become slightly relaxed over a period of last 2 months. But the moment we came into some comfort zone, suddenly the COVID came back with vengeance. Probably some cross-examination of it needs to be done. What more important and what more relevant topic than today? We'll all be blessed with deliberations by none other than Honorable Justice Manish Bhandari sir. We have amongst us today professionals, chartered accountants, young budding lawyers across India, and a very important topic and armory in the, whether be a chartered accountant or advocate, is this topic of examination, cross-examination, which no other but better person than Honorable Justice Manish Bhandari sir could have deliberated today. Sir, we took inspiration from our founder, late Dr. N.M.Ranka sir, promoted us a continuous educational program during his lifetime. He was the instrumental in formation of Tax Consultant Association Jaipur as well as Rajasthan Tax Consultants Association. And in his memory, the family and the trust decided to continue with this lecture series, which was very warm to his heart. He started this lecture series with Justice Bhatt, who started with the inaugural session. And today we are witnessing 7th round. And it is also unique that we have partnered with various associations, universities, colleges, which were close to Dr. N.M.Ranka sir. person at heart, a Gandhian, always loved to follow Gandhian philosophy and propagated Gandhian philosophy. He wrote various books. He wrote various articles. He has been chairman of more than 700 conferences and seminars which were organized under taxation in various throughout India. There would hardly be any state from Jammu Kashmir to Tamil Nadu which he would not have been, had association with or had not been a chance to be with. Most of the participants here know much about Ranka Public Charitable and also about late Dr. N.M.Ranka Sahab. So I would leave this fond memories in each one of our mind and heart, each one of us. And since we are already started late, I will pass on back to the host for deliberation on the topic. Thank you very much, sir. Thank you.
Thank you, Siddharth, sir, for explaining so well. Though we are unaware about any of the person who would be unaware about how the Ranka family and N.M. Ranka sir have contributed towards society, towards student, of upliftment of the programs and the other curriculum which were needed for the students to develop their skills in the law. Now, with I would like to invite Dr. Vijay Lakshmi ma'am, who is Director of Manipal University, Jaipur, to give welcome address on behalf of the Lexological Club and also Manipal University. Ma'am, may we please have you?
Thank you so much, Megha. Thank you. Yato dharmastato jaya. Yato dharmastato jaya. This is an insignia of Honorable Supreme Court. The meaning of this insignia is Dharm ki vijay. Dharm ki sada hi jai. And as per my view, धर्म को जीतने के लिए justice की जरूरत है. Justice is a virtue of dharma. And for getting the justice, knowledge is very, very important. So I think combination of knowledge and justice on the same platform, that is academicians, students, and Honorable Justice Mr. M.N. Bhandari Sahab, Justice J.K. Raka Sahab. I think it is a proud privilege for School of Law, Manipal University, Jaipur, that students will be benefited with the words of wisdom of both the justice. So I hope that students of School of Law and we all faculty members from this Law Department of Manipal, we will be benefited with your interaction, sir. And students are waiting for this important topic, that is examination of witnesses. On behalf of Manipal University, I welcome all the dignitaries who are present here in this webinar. And most importantly, I would recognize all the contribution of Shri N.M.Ranka Sahab, who was also associated with Manipal University since beginning. With Ranka Public Charitable Trust, we had conducted number of national moot court competitions. And during this pandemic situation, this time we were having international moot court competition. So again, with my whole heart, I welcome you all on this platform. Thank you so much. And indeed, I would like to remember our leaders of Manipal, Professor G.K. Prabhu, President, Professor N.N. Sharma, Pro President, and Professor Ravi Shankar Kamath, Registrar. Without their support and guidance, School of Law, Manipal University couldn't achieve such kind of, achievements. So thank you so much once again. And over to Megha, please. Thank you, Megha.
Thank you, ma'am. Thank you for such a warm welcome, and your understanding of justice has given us a new lineup of understanding how a justice is being equalized and is compared to the other things. Now, I would like to invite CA Satish Gupta sir to give welcome address on behalf of Rajasthan Tax Consultants Association.
Thank you,
May we
Megha.
please have you, sir?
Thank you, Megha. Honorable Mr. Justice N.M. Bhandari ji, Judge Allahabad High Court, Honorable Mr. Justice N.M.Ranka ji, former Judge Rajasthan High Court, Dr. Vijay Lakshmi Sharma, Director School of Law, Manipal University, Natwar Sharda, President TCA, Siddharth Ranka ji, Secretary Ranka Public Charitable Trust. I am seeing very known faces here. O.P. Agrawal Saab, a senior chartered accountant, my elder brother, G.P. Singhal ji, Madhusudan Singhal, Tarun Sharma, R.N. Meherwal ji, and Megha Bhargav, who is conducting this particular wonderful webinar today. I, C.A. Satish Kumar Gupta, on my personal behalf and on behalf of Rajasthan Tax Consultant Association, established in 1976, 45 years back, by Sri N.M.Ranka sir. Welcome all the dignitaries today with my heart. Friends, Rajasthan Tax Consultant Association has 2,000 plus members in the entire Rajasthan. And I would like to remember the contribution of Sri Ranka sir. He was not only pioneer, or I can say pillar of this association, but he was the father figure for all of us in this association. And he was the person who brought this association to this level, that this year, Honorable Finance Minister of the Government of India invited me as a president of Rajasthan Tax Consultant Association to discuss various issues on GST. And we have been, this RTCA has been appointed as a member of the GST committee to discuss several issues regularly on GST. Apart from this, in this pandemic COVID-19 situation, we also got the calls from the Finance Minister State, Anurag Thakur ji, regarding what steps can be used to cope up with the situation. I think this RTCA could achieve all these things only with the contribution of Sri N.M.Ranka sahab. We can never forget such a nice person. And today we are seeing this wonderful webinar under the memory of him as a lecture series by the Ranka Public Charitable Trust. And I think at this trust, we are making all the dreams true of N.M.Ranka sir. Really wonderful work by the trust also. Friends, today's topic, cross-examination, re-examination and examination chief, and the speaker, Justice N.M. Bhandari sir. I think all the attendees will be benefited like anything, because if a judge tells you about the cross-examination and re-examination, which are very important, all the income tax practitioners who are present there, we all know that simply citing the case of Andaman Timber as held by the Supreme Court, we get the case in our favor if the opportunity of cross-examination has not been given by the officer. So what is the importance of cross-examination, re-examination and examination, we all know. But the details about all these things will be told none other than by M.N. Bhandari sir. I welcome you again, sir, in this webinar today. Thank you very much. Thanks a lot for giving me this opportunity. Thank you very much. Thanks a lot. Over to Megha.
Thank you, sir. Such wise words about the development and the development of RTCA is being because of the help of N.M.Ranka sir, but also hard work of you. Being the president, we have always seen you hardworking and motivating us to getting the better ways of treating the situation. By now, I would like to invite Honorable Mr. Justice J.K. Ranka sir, former Rajasthan High Court judge, to speak a few words about the topic. May we please have you, sir? May we please have you, J.K. Ranka sir?
You need to unmute once.
Okay. Let me talk.
Yeah, okay, sorry. Thank you, Megha. My younger brother and friend, Honorable Mr. Justice M.N. Bhandari, illustrious son of Rajasthan and now adorning high seat of Allahabad High Court as the senior most judge. We welcome you this evening, Justice Bhandari sir. Respected Madam Vijay Lakshmi ji, Director of Manipal University, which is a renowned institution in its own right. My friend and President of Rajasthan Tax Consultant Association, Satish Ji Gupta, my friend and younger brother, Shri Natwar Sharda, President of Tax Consultants Association Jaipur, of whom I have been past president of both the associations. So was my father, late Dr. N.M.Ranka sir. My mother Urmila ji Ranka, my wife Renu ji Ranka, Siddharth, Sambhav. I could notice the presence of the most eminent and esteemed senior most judge, Honorable Justice S.N. Bhargav sir, former Chief Justice of Sikkim, with us in this webinar. I can notice the presence of Honorable Mr. Justice V.S. Dave sir, another celebrity judge of the country, who both at this age are giving tremendous service to the fraternity of law. Shri Gopi Agarwal ji, the past president of RTCA, TCA, and chairman of JECRC University, which has made a mark in the field of education. Well, friends, as far as Justice Bhandari Sahab is concerned, he needs no introduction. And I, for myself, am happy and delighted to have him here this evening on just a call that you are being invited to talk to, give your words of wisdom to the youngsters, the students, the young lawyers, and he readily agreed, as the honorable other judges have agreed. I've had the pleasure of sitting with him when he was in Rajasthan, and I was also in a division bench for quite a long time. And we did whatever best to the institution, to the society. And he has the caliber of not only service law, but he has excelled in civil, criminal, revenue, and of taxation laws also. I was surprised when I was sitting on division bench and we were having the roster of taxation also, and I was amazed to see his knowledge of taxation laws with clarity and all. So I'm happy that he is with us on a very vital subject, as Satish ji has already said, because that is more important. I wanted my tax lawyers and chartered accountants to know, because Section 131 witness proceedings are there, cash credits are there, bogus purchases issues come up time and again, and one should know the art of advocacy, art of cross-examination, and which is vital to upset the opposition to a great extent. I'm happy Manipal University has always has been in the forefront, have accepted our invitation to be a sponsoring partner this evening, and both the association of whom we have had a long bonding. Well, friends, I just wish to say that the issue of cross-examination is very vital. It can make a case or destroy a case. It is the keystone to a successful trial. The purpose of cross-examination is not simply to attack an adversary, but to strengthen your own case. The object of cross-examination is to check the credibility of the witness. It is one of the principal tests which the law has devised for the ascertainment of the truth, and is certainly most efficacious. Every law student or a lawyer deserves to know the art of cross-examination. I, for myself, can give my example that when I started, I completed my law, my mentor and my father said, if you are joining tax profession, that is fine, but you need to know the art of cross-examination as well. So instead of joining the chamber immediately after completing law, join a chamber of a trial court lawyer and then have the nitty-gritties of evidence, law of evidence, and art of cross-examination, which will help you later in your life. And certainly, I took the word of my mentor and my father and had my initial days in the trial court taking to the arguments of the criminal lawyers, the civil lawyers, because evidence and cross-examination of witness, re-examination, all these issues are before the trial judge. And that very evidence, which is taken, recorded by the trial court at the earliest level, goes up to the Supreme Court and is appreciated by the honorable judges of High Court and Supreme Court. So that very vital issue of cross-examination, and every lawyer, every young student, law student deserves to know what should be the basis of cross-examination, how it functions. Section 135 to 167 of Evidence Act takes care of all these things. But then, of course, my brother Justice Bhandari is here to tell you more in detail, in depth of his experience, because he has wider experience not only of Rajasthan but of Allahabad, because Allahabad is one of the biggest court of the country and he is the senior most judge. So over to Honorable Justice Bhandari Sahab for taking ahead on this vital issue for the benefit of not only students but myself as well, because I have been a student of law and would remain a student of law for all times to come. Thank you, Megha, for doing exceedingly well. I must convey to my brother Justice Bhandari Sahab that Megha and Parth, these two young students, they are into third or fourth year of law, but they have single-handedly handled all the webinars except choosing a speaker. Every aspect of the matter is being looked after by these two young students. So all credit goes to these two young buddies who would be in life after completing law, would excel in their field. Thank you, Megha, Parth, and all others who have assisted and associated me in conducting, organizing all these webinars over the years. Thank you, Megha. Take over. Thank you.
Thank you, sir. Thank you for all the words which you have given us. Thank you for telling us that indeed we know that the importance of examination and knowing about the in depth of the examination is very essential to each and everyone. It's not only regulated to the people who are studying law or people who are associated with law. It is important for each and everybody, being a citizen also, that we should know about the rights and procedures that which are being followed in examination. Now, what else would have been a treat to have such information and such in-depth knowledge about the topic from M.N. Bhandari sir. So now I would like to invite M.N. Bhandari sir, but before that, there are a few things. As sir told that everybody knows about the excellence work of sir in tax law and other fields also, but there are the few credentials which I wanted to announce. He was appointed as a judge of High Court of Rajasthan Court on July 5, 2007, transferred to Allahabad High Court and took oath as judge on March 15, 2019. Practiced in the Rajasthan High Court at Jodhpur, Jaipur Central Administrative Tribunal, Jaipur, and initially in Supreme Court in Constitution, Civil Service, Labor, Criminal Arbitration matters, and specialize in Constitution, Service, Labor, and Arbitral matters. We all are well aware about the understanding of constitutional law of Sir, and we feel immensely proud to have him here to speak about the topic, and we can't wait to hear you, sir. But before that, I would like to inform all the students that after the session of M.N. Bhandari sir, we will be having one question and answer round. So each and every student who have their question can write their question in the chat box. We will be calling you by your name and unmuting yourself, and you can ask your question in the question and answer round. So now may we please have you, sir, Justice M.N. Bhandari sir, to speak about the topic and enlighten us with the information. May we please
Thank
have
you,
you,
Megha.
sir.
Thank you, Megha, for handing over. My esteemed brother, Justice J.K. Ranka, Siddharth Ranka, family members of Ranka Charitable Trust, Director Law of Manipal University, Mr. Gupta, President Tax Consultant Association, Mr. Sada, dear students. And lastly, I cannot forget, since my brother has named a luminary, V.S. Dave Saab. He is also on webinar, I'm told. In fact, he is the best person to talk about the cross-examination and all related issues. But I am feeling fortunate to speak on the subject in the presence of Justice V.S. Dave Saab, who has practiced not only in the High Court, but in the trial court, where real feel of the examination of chief, cross-examination and re-examination that can be felt. Basically, this is required for those who work in the trial court. For me, it is said that I was practicing in the High Court only, but I may disclose that I had conducted trial, not of the criminal cases, but in labor laws, where also the cross-examination is required and is very vital. I extend my gratitude to the trust for selecting a very vital topic for today's discussion. In fact, it cannot be explained theoretically. This is a type of the art and that it needs acumen, intelligence, and tact to question the witness, how to take out the truth. Testimony of the witness is to be touched by the cross-examination, but before proceeding that, I may give the background of this provision, certain provision of Evidence Act, Indian Evidence Act, and then I'll give illustration because it would not be easy to explain otherwise, but the examples to be given that may explain how the examination of chiefs should be conducted, so as the cross-examination and re-examination. These are three vital parts which fall under Chapter 10 of Indian Evidence Act, Section 36, 137, that talks about the three types of examination. First is examination of chief. Second is cross-examination. Third is re-examination. Section 138 of Indian Evidence Act talks about the order in which the examination of the witness is to be conducted. That is, first would be examination chief, then it would be cross-examined by the other party or the party who is eager to cross-examine the witness. I'll illustrate that at times party would not be interested to cross-examine the witness also. The re-examination is conducted if needed by the party who brought the witness. These are the things which is required to be kept in mind. The order of examination I have already given, that is as per Section 138 of the Evidence Act. No, what is examination of chief? That is required to be explained first. The examination chief is narration of facts given by the witness in support of. Generally, I'm telling you, there are hostile witness which I would be debating or deliberating upon separately to give the version on behalf of the party who has brought him. Say, for revenue and the SSE, if revenue has brought a witness, general presumption remains that he would be narrating facts favorable to revenue. Maybe it go other way also. But largely, it is commonly understood that examination of chief, the witness would state the facts in his knowledge. Now, after the examination of chief, the cross-examination takes place. And here I would add, the leading question cannot be asked in the examination chief. What are leading questions is a question asked to the witness, which may have even answer therein. These type of the question cannot be asked But to my mind, the rigor of examination chief has not so much now in the civil laws and other laws, even for the income tax, because now the examination chief is allowed on affidavit. The affidavit is generally prepared by the advocates. So the art of examination chief, that only remain in the criminal cases, not in other cases, because affidavit has taken place, and that is not to be said to be a substitute, but that is called as examination chief. Like in section 138 Negotiable Instrument Act also, the provision for giving affidavit or statement on affidavit is to be taken as examination chief, that has been allowed, and by virtue of which whatever is to be stated by the witness, that has to be given in the affidavit. But an art, how to narrate the facts, and frankly speaking, in India, used to tutor the witness. I'm deliberately using the word tutoring because what has to be stated witness, that has to be tutored by the advocate concerned, and Justice Dave would agree that this is not normally permissible. Just a minute. I'm sorry, there's some problem in my mobile. I'm really sorry. There was some problem in my mobile. Megha, can I continue?
Yes, please.
We can hear you.
Okay.
Yes, sir, please can continue.
So,
Yes, sir.
I mean, the examination chief, I was saying, it is given on affidavit, generally in the civil as well as in other matters other than criminal. Now, after the examination chief, the turn of the other party comes to cross-examine the witness. Now it is to extract the truth, and cross-examination at times, and otherwise I tell it to be an art. How to extract the truth, that all depends on the advocate who is cross-examining the witness. In the cross-examination, how it is to be conducted, what is the relevance, I'll come later part. Third stage is re-examination. Re-examination is not conducted always, but if you want to ask some question, the person who brought the witness after cross-examination can re-examine the witness in cases where it is required, not in all the cases. Now, these are the three stages which is required to be taken into consideration. In examination chief, I was saying that generally we tutor the witness, why it is required or why this tendency exists. Though, I mean, off the record, I say it is not provided under the law. I'm giving the practical aspect because students who intend to practice in the trial, in the criminal side especially, they need to know how the things are going in fact, which is not given in the books. I conducted one matter of road accident where an American met with an accident on Delhi highway. He sustained injuries and a claim was made before the motor accident claims tribunal. The claim was huge. I mean, it was more than 6 crores against the roadways because he became disabled. And after going to US, he raised a claim. Now, major part of that claim was the medical treatment expenses, which was around 4.5 crores, and the rest was his income loss. Now, we conducted that case because the person was disabled and he was unable to come to India. The examination was to be done on commission. Commission means the lawyers would go to the place of the witness and they will conduct the examination. I was appearing for the roadways and other party. We went to US to conduct the examination of that witness and other witnesses who are unable to come to India. Now, the first thing which I said, I was seen, the opposite counsel tried to tutor the father of that person who sustained injuries. What was that? He was insisting, because we were at one place, so I could know, to say that father should disclose the income of his son. Now, father was adamant to say that I would not be making a statement because this is not in my personal knowledge. He said, I mean, it is going to weak our case because unless we prove the income of the injured, we are not going to sustain in the claim. Father bluntly refused. Then it was explained by the opposite counsel that this is the tendency or this is the practice in India. We tutor the witness and then accordingly statement is made, though it is not otherwise written or permissible as such, because statement of the witness should come as it is, what is the truth, not by tutoring, but I'm telling about the practice. Now this fellow refused to make a statement in regard to income of the injured. In any case, I mean, the employer was produced and he could bring the certificate in to prove the income. The vital part was about the medical claim, because it was felt that income of the family is not such or that much which can meet with the expenses of the treatment. Now the question was, who has paid the amount? Now the cross-examination was to be done of those who were treating the injured or who has raised the claim or the bills. The obvious answer can be that the person was maybe insured, because US everybody is insured because of medical expenses to be quite high. But unfortunately, that person was not injured, was not insured. The difficulty was that if he is not insured, the entire amount has to be paid by the other party, that is the roadways, against whom the claim was made. It became very difficult, but then it has to be kept in mind that your anxiety to know from where the payment came. When I started cross-examining the medical doctors and all who raised the bill towards the treatment, I asked, all right, you raised the bill, who made the payment? They immediately disclosed that it is by a Cal claim, because he was a person of California, and he disclosed that if anyone is not insured, then a claim, California claim, that is called, that guarantees the treatment part of anyone of the who is citizen of California. And this is how the amount has come. The entire amount incurred on his treatment has been paid out of the fund of Cal claim. Now I asked further whether this amount is payable if the amount is given. They said no. This is once paid, is not required to be reimbursed or repaid. Now here is a thing, in the cross-examination, what we could achieve is that the claim towards the medical, that is 4.5 crores, that can be saved by saying that this amount is not ultimately incurred or spent by the family or the injured. It is by a pocket like insurance by the state of California, and this is not required to be reimbursed. Now, this is very, very crucial. I have given this illustration to show how crucial, how material it is to cross-examine the witness. Then other cases I'll discuss. Before that, I would be saying that at times it is very, very difficult to find out or take out the truth. If the witness is very clever, then your acumen is required to find out what is the truth. And here, after the examination, because we are talking about the examination chief, cross-examination part would also come. In the criminal cases, which Justice V.S. Dave Saab has faced in many cases, because he has practiced not in trial but High Court, and was a known criminal lawyer also at that time. So in examination chief, assuming the prosecution has brought a witness to prove his case, and the witness is not supporting the prosecution case, he is to be declared as hostile. I mean, request is to be made to the court that he is not supporting the prosecution case. Therefore, he should be declared as hostile witness. Now, what is hostile witness? I have to narrate. A witness, and I'll give a small example. a witness had seen the occurrence where A was opening fire on B. B died therein. It was case of murder. Trial was going on. In a initial statement under section 161 CRPC, the witness stated that yes, A opened fire on B, and I seen that because I was present on the place of occurrence. Now, based on that, he was projected to be eyewitness. In the examination of chief, that person comes and say that either I was not present at the place of occurrence or I not seen A opening fire on B. Now, if such a witness is produced and is not supporting the prosecution case, then a request can be made that he is a hostile witness. Now, how a witness become hostile, I would be going on the practical aspect. Sometimes the witness is whenever by the other party, that is the accused party, or many cases it also happens that a person is not in fact a eyewitness, but he is projected to be eyewitness by the prosecution. They plant many witnesses. These are all hard realities in our country. Though, I mean, it is not written again in the books. Therefore, a practical aspect I'm telling you. And in that case, the hostile witness, if declared, the question would be whether accused should cross-examine that witness or not. At times he can leave because the witness produced by the prosecution is not supporting them, is not disclosing anything unfavorable to the accused. Rather, he says that I was not either present or I have not seen A opening fire on B, who died in that case. But the hostile witness, generally what we understand in the criminal side, that if the witness are not supporting prosecution case, then nothing remains. But that is again incorrect interpretation, because a statement of hostile witness can also be considered to the extent of the evidence which part corroborates his statement. In a case of murder itself, say around 302, one witness or two witnesses who are projected to be eyewitness not supporting prosecution case, they are declared to be hostile witness. The case would not be over by mere saying that the main witness have become hostile. There may be other evidences which may prove the case. That is not required to be debated right now, because then I would be going in the criminal jurisprudence and the trials, etc. What is the relevance is that the hostile witness, if it is there and you are appearing for the accused, you should be cautious whether to ask or not to ask the question in cross-examination. You should see what is the statement, even if he's been declared hostile. In many cases, even then cross-examination may be required. In others, it is not required. You can say, I have no question to ask. These are the things which is to be decided on the spot, because statement in chief is recorded by the court in the presence of the accused and all. Therefore, you have to decide then and there. Now, third thing which comes is the re-examination. If the witness is not hostile, he is narrating the facts. Say, assuming in this case, A is not a hostile witness. He says that I was present at the spot, B opened fire, which hit the A, and he died, B, and he died on the spot. Now here, there are two things. One is that he was in fact an eyewitness. He is an eyewitness. And secondly, he is a planted, not an eyewitness. Now, what is required to be seen to come out with the truth? You don't know whether he is a planted witness or he is actually eyewitness. Now, it all depends on the situation or the case history. And for the cross-examination, what is required to be done? You should command on the facts of the case. That is very, very relevant. You should be very, very deep on the facts. For the reason, assuming I give an illustration, the time of the occurrence is say around 7:30 p.m. There is little dark. Now visibility is low, and the witness who says that I was present in the time of occurrence, the question would be, what was the distance from where he had seen the witness? You can cross-examine. And if says that I was at the distance of 100 meters or 200 meters, you can create doubts that the low visibility with the distance can be seen in the occurrence. These are the things which are required to be seen. If the same thing is taken note of, that it is in the daytime the murder took place, the same question cannot be asked. Would not be relevant what was the distance. If says I was at the distance of 100 meters, the light was such one can see. So all these examples I'm giving, that you have to prepare the case thoroughly to cross-examine the witness. I had conducted one matter that is in the labor court. I was appearing for the employer. There the witness was produced, the workman himself. It was a case of termination of the workman. He was produced to show that he was not earning during the intervening period, because whenever termination is held to be illegal, generally labor court awards back wages, which comes very heavily on the employer. Now the argument remains that if the termination is held to be illegal, to save the burden, you should cross-examine the witness that he was earning somewhere, so that the burden of back wages would not come on the employer. The witness was produced by the employee. He himself was the witness. Now, to extract the truth, whether he was gainfully employed or not, it is a task, because he is again a tutored witness. The counsel appearing for the employee must have given that if any question is asked about your earning, I will say I am not earning at all. This is the general phenomena which we see in the cases. So I was knowing that he must have been tutored. So you should not ask direct questions in the cross-examination. Otherwise, the witness, if he is intelligent, was not going to give the correct answer of the truth, narrate the truth. I did not ask anything about the employment. I said, how many family members do you have? He said, we are 6 family members, wife and I, along with 4 children. I said, what is the age of your children? He said, I mean, they are teenagers. One is at the age of 12, other is 10, third is 8, and last is 5. So this became very clear that none is earning. So I said, then your wife is earning somewhere, because she is a very educated lady. He said, I mean, after laughing that she is illiterate, what to say about her education? She is not earning. Now this question, this answer came. Then I said, you must be having loan on you. Why this question was asked, I'll tell you later. He said, no, I have no loaning. I have not taken any loan. Here I ask that if you are not taking loan, none of the family members is earning, how you are surviving, how you are carrying on your livelihood. So that thing occurred, and immediately you can ask, he would not be in a position to answer that question. So these are the things, and interpretation ultimately based on the cross-examination or whatever is the statement of the witness, you have to make out a case at the final stage in the argument that the person was having 4 kids, 6 family members in all, none was earning, wife is not earning, they have not taken loan, then how they were surviving? Must be the person was earning. Now this is required for the reason that you at times are not getting the clues or a document about his employment. Even we know the workman is working somewhere else, but you don't get a proof of his working, a document of his working. So we have to ask the question. Now the cross-examination should be such where you should not ask direct question to him. Otherwise, he would give answer to the satisfaction of his party and not to your expectation. That is the art that is required. And at times, the questions have to be framed on the spot, looking to the requirement or answer given by the witness. One thing which is to be kept in mind, and I've seen, and I think at the end I will take the blessing of Justice V.S. Dave also. We have seen, I mean, cross-examination, lengthy cross-examinations are made. That is absolutely incorrect practice, according to me. Cross-examination should be very brief and specific. Why I'm saying so? Assuming a witness has said something which is favorable to you, if you want to make it very, very clear, he may improve upon. So the art is required that where you are getting a clue favorable to you, don't try to get it clear much, because he may change his statement or version. He may explain the earlier statement also. So one need to be very, very careful in asking the question. If you are getting an answer, to the extent that you can develop your case in the arguments, final arguments, should not further ask the question. But at times, we have seen, the lawyers conducting the trial and asking the cross-examination go very long. They raise question in depth, and at times you find maybe beneficial is the contradiction in the statement, but otherwise your case may be demolished with the improvement of the statement by the witness. So cross-examination is an art, is a clever move of the advocate, and it is, I'm saying, why art? It cannot be taught. It has to be understood, it has to be developed. And therefore, very successful lawyer in the trial, they were having this art. Like Justice V.S. Dave was appearing as a trial court advocate at times. He was having that knack, actually, how to cross-examine witnesses, how to take out the truth, to demolish the case of the prosecution, if you are appearing for the accused. These are the things which is to be kept in mind. Last is re-examination. That is not, again, very vital or important, because re-examination at times is conducted by the counsel who is producing the witnesses. After the cross-examination, there may be a need of re-examination, but here I explain it. And as per the judgment of the Supreme Court also, we generally understand the order of examination as given under section 138. That is the examination chief, the cross-examination, and lastly, the re-examination. But if in the re-examination, a new thing has been brought, then one can demand for cross-examination, which is not given otherwise under section 138. But court says that if a new fact has been narrated, it is to be taken as examination of chief, because for the first time, if a statement is made in the re-examination, a chance of cross-examination has to be given. If that is not given, it may affect the trial. These are the basic features which is required to be taken into consideration for examination of chief, the cross-examination, and re-examination. I already talked about the hostile witnesses, how to tackle the hostile witness also. Because if you are appearing for the prosecution and your witness is not supporting, then you should immediately pray to the court that he should be declared hostile, because ultimately the decision is to be taken by the judge whether to declare him hostile or not. But cross-examination, again, if you're appearing for the accused, that may be conducted if need be, because in the examination of chief, the person who I declared to be hostile, he may have narrated something which is adverse to the accused. On those issues only, we should conduct the cross-examination, not on other parts. The thing is, and for the clarity, the cross-examination should be conducted only on those questions or on those issues or aspects which have been disclosed or going adverse to you in evidence. That is what is required to be. Now here, because you would not only be conducting the criminal cases, there may be civil or taxation matters also. Why oral evidence? This is called as oral evidence. There are other evidences also, and for clarity, I'm saying for the students also, because tax bar is also there. There is a documentary evidence also which is produced by the either party. Now, documentary evidence, whenever it's produced, is to be proved because they are marked as exhibit. That is to be proved by oral evidence. But the contents of the document, if admitted in civil cases, etc., is not required to prove, and you should not require to cross-examine the witness unless it is so relevant or you want to demolish the contents of the document, then only. What I mean to say is, apart from the oral evidence, that is the examination in chief, the cross-examination, re-examination, the other thing is the documentary evidence. Documentary evidence also produced, and in those cases where the documentary evidence is produced, the cross-examination becomes narrow, but we should not lose sight that in many cases, even the cross-examination of witness proving a document, that may become very, very relevant. Here you would be asking that if a person has been called only to produce document, whether he can be cross-examined, the answer is no. If a person has been called only to produce a document, and that is called because the document was in his possession, he is not projected to be witnessed by either party, then he cannot be cross-examined. He would simply come and produce the document. That person is not available. But if he is produced as a witness by either party, then yes, definitely after the examination of chief, cross-examination can be made if you feel it, but that opportunity has to be given to the party. Assuming a party is not given opportunity to cross-examine the witness, then that witness cannot be considered in that case. So court are required to be to take note, and generally it happens that they, after completion of the examination of chief, are the other party to cross-examine the witness. Whatever questions are raised, they are recorded, and thereafter re-examination is done. This is how the process of examination of witness takes place. There are many vital issues which are legal, that is given under chapter 10. Certain questions are coming. I mean, Ranka Sahab, I will ask whether I should start answering that also, because this is all practical aspect which is required to be seen than theoretical. It is type of the art, I already said. So that would be useful if I answer the questions raised by the participants. Can we go like that?
Yeah, it's entirely up to you, or we have a question answer session after you complete your speech.
Okay.
Then we can take over, or it's entirely up to you, because the session is entirely up for by you till the closing. Either
Okay,
you,
thanks.
yeah,
Okay, fine. Because I was taking note of the questions also. So it is appearing on the monitor.
You can answer the questions posers raised by the students. Yeah, no
Okay,
issue.
it would be appearing on the monitor only, or they would be asking orally.
So I may repeat the question for you if you want, or the students can also directly ask the question.
That would be better. I mean, if you narrate the questions, or anyone can directly ask the questions, that would be vital, and would give knowledge to others also, because
Yes.
interactive session is always better than lecturing on the issues. And this is such a subject where you cannot lecture, and if you start lecturing, and it has to be with example. We can take the cases, criminal side also. Many cases we have seen. Though I have never conducted a trial in the criminal cases, experiences only in other cases. And this is such a art, I'm telling you, everybody should know. I mean, everybody should. For the students, I would be saying to go to the trial court to understand niceties of all the legal positions, which includes the examination of the witness, the examination of chief, the cross-examination and re-examination of the witness. This is very, very vital. I extend really, I would congratulate the Ranka Trust for selecting such a vital subject. Otherwise, what generally we do is we select the topics which remains theoretically only. These are certain practical aspects which are required to be understood. Though again, I would say, it's an art. It has to be evolved. It has to be developed. You need to put a lot of labor. You have to study the entire case before you put anyone for the cross-examination, or you conduct the case for examination of chief, etc. You need to know, you should have full command on the facts of the case, and then you should carefully read or understood the examination of chief, what statement has been made by the witness before putting cross-examination. Cross-examination, again, is required to be conducted to know the truth. Testimony of the witness and everything, whatever is relevant for the case, to improve your case, you should go for the cross-examination. But on the issues which are not at all relevant, you can avoid. And lastly, again, I would be repeating, you should be very, very specific and brief, not to repeat the questions, not to give chance to the witness to improve upon. That is what is required. We can straight go for question answer. That would be
Yes.
would be important and would enhance the knowledge or whatever is the anxiety or the questions in the mind of anyone who is participating on this webinar.
Very well, sir. What our system is that we request the student to directly speak upon, so that confidence level of the student also rises.
That would be wonderful. That would
Yes.
be wonderful.
Megha, adopt the same system as we have been doing.
Okay, sir. So with that, I would like to invite Mansi Sharma to speak about, to ask their question. Mansi, just a second, sir. We will be unmuting her so that she can ask her question to you.
Good evening, sir. Am I
Good
audible?
evening.
Yes, you're audible.
Sir, I wanted to ask that what type of questions are generally considered improper and most judges will sustain objection to them?
No, I mean, that is very relevant. I mean, what type of question I have already said, I mean, it should be relevant to the issue. See, I mean, what is the purpose of cross-examination is to extract the truth. If a witness is making incorrect or false statement, your art is to extract the truth. And that is the purpose of cross-examination. Now, what should be the question depends on the statement of the witness. But only one thing which is to be kept in mind, that you should be very, very alert. And it's an art. Again, I would say, whenever you want to extract the truth, don't ask direct questions, because the witness would be clever. He would not narrate the correct thing, even if he knows. So you have to frame the question in such a manner where you can achieve the goal, but not directly. You have to go through a media that you are asking certain questions which are not directly relevant, but becomes relevant at times. Like I have given an illustration, whether an employee was gainfully employed or not. I not ask him, you are earning or how you are carrying on your livelihood. What I ask, how many family members, whether anybody is earning, you have taken loan, because he can ultimately say that I could carry on after taking the loan. So I blocked all those issues which could have improved the case of the employee. And their last remains that if he was not having a source of earning, then how he could survive? Meaning thereby he was earning somewhere. And this is how you need to conduct the cross-examination. Now, you have asked the other question, when the question can be denied, it is objected by the court. It is only when it is not at all relevant to the subject. If you are asking absolutely irrelevant questions, the court can say that this question is not permitted. So it has to be relevance to the issue. And if the objection is raised by the judge, you can say it is relevant, and you could say in such a word that the witness may not get the reason of asking the question. That is the cleverness which is required to be applied by you. You got the answer, or any confusion now?
Absolutely, sir. Even I have understood the concept what you were telling. So the next question is from Lavanya Sharma. We'll be unmuting her so that she can ask her question to you, sir.
Yeah, please. Yes, Lavanya. Mega, I'm not getting the questions.
Megha, we can proceed to next. let Lavanya join then.
Okay. So the next question is from Sudhanshu Yadav.
Yes.
Okay, you
First
may
of-
proceed with your question.
Thank you. Thank you. First of all, thank you to all of you for this enlightened session and for giving this opportunity to ask question. My question is, like, being a law student, like I am a first year law student, and any law student. So, what qualities should we nurture from this level only to be a good artist as a lawyer in
Well, I
cross
mean,
examining as well as other aspects of law?
you
What
are in
qualities?
first year.
Yeah,
You are in
yes, sir.
first year.
Yes, sir.
Well, it's too early, but I mean, I appreciate your anxiety to know about it. I mean, the best quality in the lawyer, I mean, not related to the issue. The best quality is to know about the law first, know about the facts, and what is the advocacy. It is an art, again, how to convey it to the judge. Now, you should know the psychology of the judge. You should be reader of the psychology of the judge. Because arguing the High Court, we need to read the psychology of the judge, what is there in his mind. And if you can understand that, you would be quick to answer his question. And if you fail, you may lose. Because in the High Court, you hardly get time to answer the questions. And you have to be very, very particular, and that can be only when you are master of the facts, you have studied the case, and you know the law also. What is required is to put in lot of labor. You should know, and for that, one thing I would be add from this platform. Today's scenario, what we do is whenever certain questions is to be asked, and on that judgment is to be taken out, what we go is we go on SCC online or Madhu Patra, etc. We'll put a question and get an answer. Whatever the judgment, you will get it. At the times when we were practicing, this facility was not available. We need to consult the books. And in reading the books at times, and many times, we were not easily getting the answer of the question we are required to extract, to put our case. Now, what we were doing is reading irrelevant facts, also irrelevant things or irrelevant law for that case. But you never know when it will become relevant for any other case. The knowledge was enhanced because it remained in your memory, whatever has been read. That practice has gone. Now you want a ready reckoner available for you. This is not enhancing your knowledge. Enhancement of knowledge needs a lot of studies, not only on the subject you are dealing with directly. What the lawyers now are doing, whenever case is coming, they will extract or make the find out what are the judgment on the issue. Research would be limited to the question involved in there. The knowledge is enhanced only for a particular issue, not all the issues. In our times, and Justice Ranka is there, Justice Dave is there, you used to have ready reckoner. I mean, the clarity of the law in the mind was there whenever case has come. We would be saying that, yes, you have a case or you don't have the case. Don't file. I mean, you are not going to succeed in the court. So that is what is required. You need to work hard. And for that, I would be saying, I would not say that don't use SC online or Manupatra. Do it. But before that, you should try to read the books. It is going to enhance your overall knowledge, which is very, very much required.
Yeah.
Any other? I mean,
Yes,
you
sir,
are in first
indeed, sir.
year,
So
but
there are lines of questions, sir. I have to restrict because we are delaying time. So our last question is from Komal Mathur.
okay, I'll give the short answer now.
No, sir. So the last question is from Komal Mathur. We'll be unmuting her so that she can ask her question.
Yes, Komal.
Neha,
Yes, Komal.
Neha Garg is also asked. She has raised hands.
Neha can be called.
Yes, sir. I think we should skip for Komal Mathur. We'll be proceeding with Neha Garg.
Yes, ma'am.
Yeah.
Hello, sir. Good evening.
Neha.
Sir, my question is to you. I cannot start my video. I'm very sorry at the moment. My question is to you. If we call a expert, a medical expert, or an investigating officer on the stand for witnessing, uh, for that, what kind of questions we should ask them, and what are the how can we make them rely on the case, and that would benefit a counsel on its behalf?
Neha, I mean, first thing is whether you are appearing for the prosecution or accused, it all depends. Investigating officer is called, I mean, he is there, and generally he would be there to prove the case of prosecution. If you are appearing for the prosecution, then I mean, the statement of the witness should be to prove the case, assuming it is a case of murder or attempt to murder 307. The relevance of the question which is required to be asked in the examination of chief is to prove the case. Now that would be based on the material he has collected during the case course of investigation. Whatever material has been collected to prove the case, those questions is required to be asked in the examination of chief. Now, if you are appearing for the prosecution, for the accused, the question to the investigating officer would be very, very relevant and crucial, because he would be a key witness to prove the prosecution case. It is your effort would be to demolish his version or the case of the prosecution. Now, it is depending on the type of the case, the statement of the witness, cross-examination has to be framed depending on the situation you are obtaining. Like I had said, in a murder case, A opened fire on B, B died. Now the investigation was conducted by the person and he has presented A to be eyewitness. There are two eventuality. A is really eyewitness or he is not a eyewitness but planted. It happens. This is a hard reality. It happens also. And it is happening more. I've seen recently in UP also. Now the art is to extract the truth. If he is not eyewitness, then I mean your question would be framed in such a manner where you can extract that he has been implanted, because a person who was not present would not stand if you cleverly ask the question. He would somewhere make a statement either in contradiction to the other witnesses or in such a manner where you can present at the time of argument that he was not in fact a witness, or he has not seen the occurrence, or his presence is not natural. There are many other aspects which is to be taken note of. In-depth knowledge of the criminal law is required for that. So it all depends on the situation, the statement of the witness, the material collected therein. It all depends on that.
By this absolute answer, we would be ending our question and answer round. So
Right.
it was amazing interacting with you. It is like, sir, everybody knows about the cross examination and how the process in the courts works, but the things which stuck in the students mind is how the procedures actually work, because we also understand the things which are being written in the books in the practical life of the court is way too different. And by your examples and by your experience, you have somewhere has given us a clear picture that what are being procedures which are being followed in the courts, and how they are being authenticated on the every stage, and how they are being denied. Even in the questions, I personally find this thing so that whenever you were answering the question, every answer was on the basis of the personal experience. So
Yeah,
that was the most heroic thing which we have learned from today's webinar. So by ending our webinar, I would like to invite CA Nathu Sharda sir, President of TCA, for vote of thanks on behalf of TCA. May we please have you, sir?
Sorry, Megha. Thank you, Megha. Audible, Megha?
Yes, sir.
Hello?
Yes, sir. You're audible, sir.
Oh, thank you, Megha. thank you, the Raka Public Charitable Trust, for giving me this opportunity to express the vote of thanks. First of all, I would like to tribute to Sri N.M.Ranka sir. N.M.Ranka sir was the father figure of this profession. He was the founder of the Tax Consultant Association. He was the patron of the Tax Consultant Association. Only few line I will speak about him. जो मरुस्थल में रंगीन गुल खिल गए, जो समुद्र में भटकों को तट मिल गए, सानिध्य ऐसा मिला उनका जैसे सबरी को उनके प्रभु मिल गए. That was the figure of Sri N.M.Ranka sir. Respected Honorable Manish Bhandari sir, respected Honorable J.K. Raka sir, Satish Gupta ji, Vijay Lakshmi Sharma ji, Siddharth Raka ji, Megha and Parth. Today it is very nice program, and I would like to thanks Honorable Justice Manish Bhandari sir that he has spared the valuable time to speak to the students of the law, to speak with the students of the tax fraternity. Thank you very much. I would like to say a few lines about Sri Manish Bhandari sir. नजरों को नजारों की कमी नहीं होती, नजरों को नजारों की कमी नहीं होती, फूलों को बहारों की कमी नहीं होती. बहुत बहुत आभार कि आपने हमें समय दिया, क्योंकि आप आसमां हैं और आसमां को सितारों की कमी नहीं होती. Very thanks to Sri Manish Bhandari sir. My next thanks to Honorable J.K. Raka sir, that he is doing very nice in the memory of N.M.Ranka sir, and this is the 7th lecture which he is organizing, and it is my privilege and my luck that he has joined this Tax Consultant Association in this series. Thank you to Sri J.K. Raka sir. Thank you Satish Gupta ji. Thank you Vijay Lakshmi ji, and thank you Megha and Parth for nicely conducting this session. And my thanks to galaxy of the judges, including Dave sir, O.P. Agrawal sir, and all audience who present here. Thanks to all on behalf of the Tax Consultant Association. Thank you very much, sir. Over to Megha.
Thank you, sir. Thank you, sir. So now I would like to invite Mr. Advocate Sambhav Ranka, sir, for the vote of thanks. May we please have you, sir?
Yes, thank you, Megha. It's my Honorable Justice Shri Muniji Mandari, eminent judges, dignitaries, esteemed members from RTCA, members from Manipal University School of Law, and most importantly, the students of law. It's my honor, privilege, and absolute pride to propose the vote of thanks for this 7th N.M.Ranka Memorial Lecture Series, which is organized in association with RTCA and the Manipal University of Law. Honorable Justice Bhandari, you are absolutely, without doubt, a family member to us, and the kind of session that we have had, I'm absolutely glad that the intricacies which you picked up, and rightly on the topic, I think so. What importantly, we should note, the topic had one aspect written, that practical aspects along with cross-examination, re-examination, and examination in chief. I think so, sir, you have hit the nail by really covering the practical aspects. I think so, it did remind me of my college days when I was pursuing my law. I think we all used to look to certain professors who used to give us practical examples of how really you apply the principles of law, and which is exactly we could hear from you, and which was absolutely a pleasure to hear. And I'm sure all the students would have learned a lot, and really there were hard-hitting nail messages in your speech, which will go a long way for all the students. We have certainly gained a lot hearing you today, sir. Thank you for gracing us. It was an absolute pleasure. My deep sense of appreciation and gratitude goes out to the RTCA, the School of Law, Manipal University, and everybody who has been around here, who has managed and made sure this webinar goes out in full success. Especially the RTCA and Manipal University, they have been the strong pillars because of which this webinar could not have been possible. I would like to thank each and every member who has been present on this webinar and the lecture series. This is the 7th memorial lecture as part of the series, and with the impetus and the kind of the love, and everyone has appreciated this. that gives us more enthusiasm to make sure that we continue hosting the lecture series with greater zeal and vigor. I want to heartfully thank Megha and Parth, who have been wonderful, and they have made sure just on their shoulders the entire webinar has been organized well and successfully, and the entire team alongside. The primary source of inspiration behind this series absolutely has been Dr. Shri N.M.Ranka, and he continues to be with us, and his life has been an inspiration and motivation for all of us. He'll be continuing to be the guiding light for this lecture series, and we will look forward to having you again for the next one. With this, once again, I'm most grateful to Honorable Justice Shri Manishji Bhandari and everyone present on this lecture series for making it a learning success. Times are uncertain once again in front of us, and we wish you full safety and best of health to one and all. Thank you very much.
Thank you, sir. So by this, we end our webinar. Unless J.K. Ranka sir wants to say.
I
Yes,
just
sir.
want to add that the
Yes,
next webinar would be conducted by Honorable Mr. Justice R.C. Lahoti, former Chief Justice of India, who has agreed to be with us on this platform on 15th May, just for information of all students and eminent members present in this August webinar. Thank you, Justice Bhandari Sahab, for a very nice, elaborate and hot topic for the students. Indeed, I also gained substantially by your exposure and practical issues uh, given by you, and certainly it's a great boon to everyone, including all professional chartered accountants and advocates present in this webinar in a large number. Thank you. Thank you all, Vijay Lakshmi ji, Satish ji, Natwar ji, and all friends in RTCA and TCA, and my young students present in large number. Thank you. Great day.
Thank you.
Thank you, sir.
Thank you, sir.
Thank you.